Next up here on the H&M Trucking podcast, I am, of course, joined by my co-host, Denny Stone, and I've got H&M owner-operator Terry Smiles Oatman on the line with me. Smiles, how you doing over there, man? Are you smiling right now?
Actually, yes. It's kind of plastered there.
Perfect. Well, thank you so much for being here today. It's been a while since we've had you on the podcast, and we're very happy to have you back, although our subject matter today might not be as fun as we've talked about in the past. It looks like there's some funny legislation being tabled right now out in California. The law is called AB 5, and it appears that the state wants to enforce this controversial law that aims to reclassify independent contractors as motor carrier employees. And we're going to use some different vocabulary during this, obviously, but independent contractor, owner, operator, one and the same for the intents and purposes of what we're talking about here. And Smiles, as an owner operator, have you read into this legislation at all? Have you looked into it? Are you familiar with it?
No, but my brain and my vocabulary has so many contradictions on the terms that were just used in one statement.
Well, feel free to correct me. You are the expert here. I am just a dude reading words on a page, so.
You're reading the words on the page pretty much verbatim based on how I understand California legislators. Okay. Oh, goodness God. That just made my head hurt. That's one of those brain teaser ones that you just have to stop and think about. Like, how can you be that stupid?
You know, I'll tell a little joke here that might bring Terry's thoughts here into a better picture for those of you listening. So there's a genie on a beach, and a guy finds the genie, and the genie says, "I'm only going to grant you one wish." And the guy says, "Okay, I want a road from here on the coast of California. I want it to go all the way to Hawaii." The genie says, "Really? That's your best wish? That's all you could come up with? You only get one, man." And he says, "Fine. I want to understand California legislators." The genie says, "Did you want 2 lanes or 4?
I knew right where you were going when you said one wish. I knew right where that joke was going. I was like, yep, I know that one. Oh, yeah, because it's so accurate.
And it can be used in any context for anything. And, it's really a good starting point to where we're at today. This rule is aiming to make it so that owner-operators really aren't a thing anymore if they're connected with a carrier, is what I understand here. And, Denny, I don't know if you've had
The wording is verbatim to your understanding, yes.
Okay.
They're trying to, and they did it with Uber and Lyft, and Uber and Lyft basically slapped it in their face, but they were trying to start this with those systems. And anybody who pays any kind of attention to life in general as it's evolved right now understands that Lyft and Uber's just taxi services, right? Mm-hmm. Where people use their own cars. Well, California passed a law that if your company provides a service and you are paying people part of your revenue to do that service, even if it's with their vehicles, that they're deemed employees.
Gotcha.
Well, Uber and Lyft kind of laughed at the California government on that one, because Uber and Lyft are nothing more than a software program that provides this service that both the drivers are making income from and passengers are getting a ride from. There, in turn, California's law completely had no effect on the targeted group.
But it sounds like the reason that this is going to target owner-operators is maybe because the verbiage in this law states that if you're providing that service using company equipment, then technically you should be an employee of the company rather than an independent contractor. Is that correct?
And that's exactly what they're trying to do. Is they're trying to make it to where in California, Lyft and Uber drivers, because they are using a company-provided application on their phone, are deemed company employees. That is the verbiage that they're trying to hit. And in order to do so, they have to target owner-operating truck drivers and everything else, because we use equipment of the companies we're normally signed on with.
Mm-hmm. Right. Like you own the truck, you don't necessarily own the trailer.
Correct. And H&M prefers that we run their trailers. That way they know they're newer, better looking, better maintenance, and whatnot. And I respect it. It makes my life, oh my God, so much easier. But it is that verbatim stipulation that H&M would like to keep that makes it to where California would like to deem me a company driver and make H&M give me company benefits.
The problem here is you've also got a judge that seems firmly implanted in the California way of thinking. I'm going to read a short excerpt here from the very end of this article. And by the way, this article that we are pulling some info from is entitled "Federal Judge Denies CTA Challenge to California AB5." And you can find that over at Transport Topics. Thanks to Transport Topics for putting together such a great article here. What this says here is that, quote, "The state's defendants have never articulated how a motor carrier can possibly satisfy the statute, including prong B of the ABC test," which we'll talk about here in a minute, "and they remain intent on enforcing the law against motor carriers. They thus continue to threaten irrevocable harm to plaintiffs and the owner-operators who have built businesses in reliance on federal law." So that is the lawyers for the California Trucking Association who's fighting this, saying you are threatening irrevocable harm to all of our owner-operators and the carriers that employ them, where the court came back and disagreed directly and said, quote, "While the jury is out as to whether AB5 substantially affects carrier prices, routes, or services, it does not attempt to do so directly." Well, I don't give a damn if they do it directly. This is our problem with all the legislation that gets passed in this industry, is that we shoot first and ask questions later. Shouldn't there be studies funded on this as to whether or not it does negatively affect carrier prices, routes, or services, or the owner-operators themselves before we strike this law into effectiveness? I mean, right now they're being challenged on the basis of discrimination. And the judge just said, hey, if it's discriminatory, we didn't do it on purpose. That's not an okay excuse in my book. That sounds like a loophole, if anything. At best, it sounds like a loophole.
Is that enforceable for carriers that are not based in California? Can California say, okay, H&M's based in Omaha, we're going to make them comply to our law? Is that?
That's what they want.
They'll say that you can't run in California if you don't. That's
just like their clean air compliance. Yeah. Just like their clean air compliance.
I mean, there's got to be a contingency of drivers out there, Denny, to what you just said. A contingency of drivers to go, great, make the law in California so that I never have to cross the state line again.
Hey, I had a buddy that threatened to set up a little mini gift shop at the border selling gerbils because apparently years ago you couldn't run air conditioner in your cab to keep your human body cool when it was 120 degrees. But if you had a pet, then California cares about the animals.
Oh, good.
So he said, I'll just sell gerbils and I'll buy them back when you come out of the state.